Hello, I'm Lucien Greaves, co-founder of and spokesperson for the Satanic Temple. I'm with Matt Kezhaya, our general counsel, and Stu Haan, also counsel, who we've used on occasion. And we occasionally give live stream legal updates of things that are going on in the legal world related to TST or church-state issues. And it's been a while since we've had one. In more recent news, we had Mahmoud versus Taylor, which was a Supreme Court decision that allows parents to opt their children out of culture war or politically laden teaching materials if they feel that it significantly gets in the way of the child's religious upbringing. And while a lot of people were upset about this ruling on the grounds that it apparently is meant to allow parents to opt children out of LGBT story times, it also opens up, I think, a world of opportunity for us to have new legal leverage to confront "In God We Trust" signs in schools, Ten Commandments being posted in schools, along with religious instruction attempting to be introduced into schools. There are schools and school districts, and particularly Ryan Walter, the state superintendent of Oklahoma, trying to introduce religious teachings into the school district. And I think it's really difficult now for the courts to not allow us to opt out on religious grounds. And as I've written about on my Substack, I think non-belief is enough. I think we really need to assert the notion of religious opinion being just as protected as any type of superstitious religious belief. And there's been a long, I think, misguided campaign from certain atheist circles to disassociate itself from anything religion to the point where I feel they would deny or argue themselves out of protected status when it comes to freedom of religion or freedom from religion. But I think people should grow comfortable stating that their religion is atheist or non-believer if they don't have affirmative beliefs of their own, and hold to their rights on those grounds, because this was never supposed to stratify society on religious grounds. Everybody's supposed to be treated equally. And in fact, when they put these laws forward, they always claim that they're giving religion an equal footing. We also had the Trump memo, which went out, that claimed that federal employees now can proselytize to the rest of their coworkers, including putting up signs in their cubicles, offices, or wherever they work related to their religious beliefs, to be able to wear religious accoutrements, and to even try to persuade other people in the workplace that their beliefs are correct. Here again, there's another side to this, and I think non-believers and certainly Satanists or whomever else should feel free and know that they can also post their beliefs, and they can also argue against somebody else's deeply held beliefs. If your own belief is that their beliefs are bullshit, I feel like they've just opened the door. And I don't know, I mean, we do know why, but I think it's a really misguided path forward to open these divisions. But I think we have to respond to them to a certain degree, and show that that we equally benefit from these things. Because while they might be passing laws, regulations, putting out memos or whatever that are intended to benefit one specific group, it's still constitutionally impossible just to single out one group and elevate them above the other. I feel that far too often people concede things to the other side when they recognize the intent of certain legislation, and think it's some remarkable prank we pull when we utilize these rights for our own. But that's the way this is supposed to work, and it was the way it was always supposed to work. And we're not utilizing a loophole. We're showing the law for what it is and what it should be. And I think people should understand the value in that, and they need to exercise their rights. And if they don't, it's more easy to take those rights away. When you assume those rights were never there, when the broad population assumes those rights were never there, they don't notice when they're taken away, and they say nothing when they formally are taken away. And we're seeing the boundaries tested, and I think the boundaries being tested are also indicative of seeing what the public response will be. if we say nothing, I think judges will know that they won't raise alarms or cause outrage when they take the next step. I think there has to be certain boundaries where at certain points we get loud. And there's better ways of getting loud than just going online or shouting and holding up signs. Sometimes you act upon the new rights they've given you, the unintentional consequences of the rulings that they put forward. Anyways, after all that grandstanding, we actually, unless either of you have anything to say about the Trump memo or Mahmoud versus Taylor, I can move into our Boston 2 case.
Well, I mean, just in a general sense, I feel like it's yet another example of they create a law that gives us an avenue to actually have more rights than they ever intended us to have. And I think in order to enforce that, it makes our job even more imperative that we speak up with these things, especially the concept that there's a there's an opt out now rule for if a religious instruction or if some kind of non-religious instruction interferes with a religious belief. So, for example, before that, if with when you have like a Ten Commandments or a In God We Trust, especially In God We Trust in schools, I felt like there wasn't really an exact mechanism by which we could counter that unless we put up some kind of satanic, seven tenets in the classrooms, and that's not really our thing since we don't proselytize. However, if they have an opt out measure now, what we can do is now say, hey, now that you've put this in the classroom, it's interfering with an alternative religious belief. And it's just funny that they would do this simultaneously. They would try to enforce In God We Trust in classrooms, and then also give the opt out for instruction that might not comply with one's deeply held beliefs. And again, this just demonstrates how short sighted all these rules generally are, and how it's not ever really about religious liberty. It's about Christian supremacy without them ever thinking that someone's going to speak up. So I agree with you in that it's going to become absolutely necessary to enforce these laws. And like you said, we're not here to change the law. We're here to actually have them enforce the laws that they put in place in an unintended way for what they were attempting to do.
Yeah, I read an article earlier today where the point was made that rules are more important than rulers. And I think that's the situation we're in right now. Constitutional law still exists, and I think there's still real hesitation to undermine or overturn some of the very fundamentals of constitutional law. But you have a lot of people pretending that those things aren't even there anymore. And that just makes them, like I said, entirely open to being dismissed entirely, or being codified that those rights are no longer there. I mean, it was something different when we started during the Obama administration in 2014, and everybody thought what we were doing was hilarious, and that our bid to put a Baphomet monument next to a Ten Commandments monument on Capitol grounds was this huge prank that was somehow seemed very low stakes to a lot of the media covering it, that we were just kind of engaging in the culture war, and it was another way to own the Christian nationalists. But I think these efforts have always been very important, and it's very important that people realize why they're important and that we are not abusing the law. This is what the law is. It's an abuse of the law to give anybody exclusive privilege in that way, to make a tiered kind of citizenship. And we don't have that yet. We don't have that, and we will if we allow it to happen. And when we accept our defeat in advance and say that we're going to act upon what we think the intended purpose was of something like Mahmoud versus Taylor or this memo, then we've already given up and we've already lost. And if it's codified that these rights of ours are taken away in that kind of environment, we have nobody to blame but ourselves. Anyway,
I'd add
the
on.
topic, yeah, the topic of the discussion really is a lawsuit we are now. We have filed, in fact, we've gone past the submission of the motions to dismiss, and it's our second lawsuit in Boston, which I forget what year this started up. Remind me again, Matt.
The
the specific complaint? When was it filed, or when's the
When
timeline?
well, when was Shirtlift? Here's
I think
what.
it's May 2nd, 2022. It's either May
Yeah, this
2nd
has been
or 3rd,
years in the
2022.
making, but Boston essentially was allowing any group to raise a flag in the public forum outside the city hall. They have a bunch of flag poles, and people were putting up uh, flags indicating different interests. And then a Christian group came around and wanted to hoist a flag that had the Christian cross on it, and the city said no. So they sued. It went all the way to the Supreme Court, and the Supreme Court said no. Boston had opened up a public forum in the same way Boston did when they were allowing prayer to open up city council meetings. But you can see the difference between Christians pushing the lawsuit and Satanists pushing the lawsuit. This one made it all the way to the Supreme Court, and the Supreme Court said you have to fly the flag. We sued because it was only it was a lion's share of the prayers were Christian in the at the city council meetings, and in fact, city council members were just recruiting their friends to pray. It seemed in certain cases, and paying them. They're paying them to do this, and then they denied us, and they got away with it because we had a shitty judge, and the judge wasn't going to hear us out on any of it and made that very clear. And so Boston was essentially allowed uh, just to engage in proselytizing a specific religion in their city council meetings, and that's where we are. But in the case of the flag being raised, we filed to also raise our flag the day after, I think, the shirtlift ruling came out. And Boston said, hang on, we'll get back to you. And then they revised their rules to say that any of the flags being flown now were going to be approved by the mayor, and it's going to be speech, government speech that they're engaging in. It's not a public forum. So then retroactively, they denied us. They denied us after changing the rules. And so we're suing. And then they filed a motion to dismiss, and I'm not sure what the core of that complaint is, but I'll let Matt get into the details.
Sure. To supplement a little bit, it was May 2nd that Shirtlift came out. May 3rd, we issued our application through Boston's recognized system for soliciting these flags. So to kind of drill down a little bit into the First Amendment scope of things, you have many kinds of government platforms in which speech takes place. So it's government property, speech is taking place in it, and it's private speech, and there are varying rules depending on the nature of the government property at issue. So you have traditional government, traditional public fora, which are quintessentially traditional places where private speech takes place, and this is where the people are heard. You're talking parks, you're talking sidewalks, you're talking streets. Those are your quintessential traditional public fora. For the government to restrict speech in those areas, typically they need what's called, to survive, what's called strict scrutiny, which means they have to have some super important government interest that is strictly tailored to that interest in order for this speech restriction to survive. Those are traditional public fora. Then you have designated public fora, which are places that aren't, for example, streets or sidewalks, in which the government has designated this is a place, it's government property, but speech can take place on this property. So you have designated ones for limited purposes. Those are called limited public fora. As the cases have kind of borne out, public prayer on public property in the voice of the government is government speech. It's not private speech taking place in those places. But for example, you might have like a public forum, literally a messaging board, or literally a physical board in which specific kinds of events are advertised. You have to advertise those kinds of events in order for your speech to have protection. If it's not within those kinds of events, then government can basically take it down. So all said, what Shirtlift stands for is this flagpole that the city of Boston solicits applications to just, whoever wants to fly a flag on this here pole can. That made it a public forum, specifically a designated public forum. That happened on May 2nd. Supreme Court says that is a traditional, essentially it's the same rules as traditional public forums. It's essentially a traditional public forum, this here poll. Now, May 3rd, we issue our application through the government platform that says we are soliciting applications to fly your flag on this pole. So it's different from, for example, our prayer cases in which the government, and specifically Boston 1, in which Boston was saying you have to be a political insider in order to give the prayer. This is completely different from that. This is, they said, come one, come all. We rubber stamp every application that has come our way up until the Christian flag. So shirtless stands, importantly, shirtless stands for the proposition, not that the Christians are entitled to better treatment than the rest of the public. Shirtless stands for the proposition that they're entitled to the same treatment as the rest of the public. So when Boston said no to the Christians because it's religious speech, that violated free speech, free exercise. We're using those exact same theories in our complaint, to which they respond, but we've changed the rules now. We're no longer just rubber stamping all applications that came our way, which would be a fine theory if we came forth with our application, say 4 months later after they changed the rules. But we didn't do
But they
that.
didn't change the rules and say they weren't going to fly the Christian flag either. They flied the Christian flag at a certain point for about, 24 hours or something like that.
Yeah, it was like a 2-hour ceremony.
Okay.
So,
okay. Oh,
so
2
the
hours.
timeline goes
Okay.
like this. May 2, short-lived comes out. May 3, we issue our application. We kind of get tossed aside a couple of weeks later. They kind of give us a non-committal, everything's on hold right now pending legal review. We'll let you know when things are back up. Then about 2 months later, in early July, Boston and the Christians enter into what's called a consent decree, which is where the two parties agree that the court will order such and such pursuant to the terms of the decree, in which Boston says that the Christians are exempt from any kind of regulation. So under the text of that decree, technically, the Christians can come forward no matter what these new rules are, no matter what this new ordinance is. They can come in whenever and say, we want to fly the flag now. And that's a thing that under the decree, they're allowed to do because it's not time limited. It's not one time you're entitled to fly the flag. So they set forth, this is going to be the date on which the Christians are flying their flag. I don't remember the exact date. It was early August. The day before early August, when the Christians are going to fly their flag, they file an ordinance that says all flags moving forward are going to be the official viewpoint of the city of Boston, which allows them, ostensibly at least, to pick and choose whatever flags they want to fly. We contend that they are just continuing the old course of conduct prior to the Christians coming in, just rubber stamping whoever wants in. But we won't know that until discovery. So
I don't fully understand the assertion that they can now fly these flags and it be government speech, because they were not going to fly the Christian flag. They didn't want to do that. But I get the impression that they feel like they could if they wanted to, given that they took this position in the city council prayer issue, that just because counselors themselves have chosen friends of theirs or advantageous contacts of theirs whom they were going to pay to get up and pray, that somehow this process was legally protected in some way, that it wasn't just another method by which you give the government the right to dictate religious speech and that type of thing. It was more, they were trying to make it sound like, I think it was the individual preference of these counselors and not necessarily government speech, but you just need to go through this process. But anytime you have some government flunkies picking between one or the other, I feel that that's as bad as any other time they're doing that. So what are the limits when they say that they now are going to adopt this space as government speech and they're going to fly these flags as being flags that put forward the position of the Boston City Council. What if the Boston City Council decided they did want to fly a Christian flag? Is that what they're trying to say? Or are they saying that there's certain opinions that are within these boundaries of acceptable government speech that they're recognizing?
So broadly stated, the government speech doctrine, you have to understand the expansive nature of what is speech when we're talking about the First Amendment. It's literally any kind of expressive activity, not just the words that you use, but also symbolic actions that you take. It is a very, very expansive notion. So the purpose of government speech doctrine is so that the government can take policy positions. For example, if I had a free speech right, for example, because Texas doesn't like abortion and I'm going to sue for free speech, and Texas is outlawing abortion somehow impinges my right to believe in abortion, that would be untenable, because then the government can't take really any policy standpoint. They cannot advocate, for example, evolution is a thing. They cannot advocate that global warming is or is not a thing, or 60 miles an hour is the correct speed limit. This is the utility that the government speech doctrine provides. However, it is bounded by the Establishment Clause. In fact, to the best of my knowledge, the Establishment Clause is the only thing that binds government speech. The government cannot, for example, say, like they can say 60 miles an hour is the correct speed limit. They cannot say this is the correct religion. So that is the binding on it. Now, the difficulty with prayer cases is basically the fuckery that is the First Amendment, because there was a case back in the 80s in which someone said, hey, I don't like this government prayer business. It seems like the government is proselytizing a very particular viewpoint. And in 1982, in a case called Marsh versus Chambers, Supreme Court said, well, legislative prayer is unique. That's kind of the difficulty that we have with the Establishment Clause cases, is from about approximately the 70s until about present, the Establishment Clause has been willed away time and again, so that it really doesn't mean too much. There are very few things that is an Establishment Clause violation anymore, which is the utility of free speech, free exercise for non-believers. So, all said, their position in the motion to dismiss is that the Supreme Court left it open for us to change our rules. They said under the current rules, the Christians have to be allowed in because we've been rubber stamping all these applications for the last 15 years. But nothing's stopping us from changing those rules. So we're changing the rules now.
But isn't it illegal universal that you can't change these things and retroactively apply them? I mean, we put in the application while the rules were what they were. And given our history with Boston, we have every reason to believe that they were wanting to change the rules to keep us out, because they would not let us fly a flag for 2 hours. That's just going too far.
Right. And that's the principle that we're relying on, is had they changed their rules before Shurtleff came out, perhaps they'd have an argument. But they didn't change the rules until after they denied our application. So why did they deny our application? That's a triable issue of fact. Right. Why did they contend, oh, well, we put all flag raisings on pause until basically August, call it 3-ish, when they flew the Christian flag. And then the new rules didn't take effect until about a week thereafter, to which we respond, okay, well, once you flew that Christian flag, you opened the door. You don't get to say all flags moving forward are going to be the official viewpoint of Boston, and then not have a very clear preference issue when the only flag you ever fly from then onward is the Christian flag. Minimally, under that, it was a 10-day period from the time they filed the ordinance to the time it was enacted. Minimally, during that 10-day period, they should have given us notice per their about 2 weeks after our application, per their promise, that they would notify us that these things have resumed. They didn't do that. Well, why not? That's a triable issue of fact. And where we're at right now in the motion to dismiss stage is the complaint controls. We say they didn't want us in because we're a disfavored religion. the court's bound by that right now.
I was worried about this one from a PR perspective because I felt like people might not understand why this is worth fighting because they, flew the Christian flag for 2 hours. Doesn't look like they'll fly it again. They changed their rules and looks like we're litigating something that's said and done. But it's not like that. And we've really got a problem with government agencies all over the place, city councils or whomever, trying to apply rules to us retroactively or shutting down forums just at the point where they've had their fun, but then we come along and they say, okay, this isn't available to people anymore. And pretty soon what you have is these things being open and shut and then maybe even open again on the grounds that they don't like a certain applicant or whatever else, but they know there's no repercussions. And I feel that's a dangerous precedent to set, and we need to fight it when they do pull the plug from us. And I think our Belle Plaine case was similar in that way, where we were approved to make a monument to go into a Veterans Memorial Park where they had a Christian Veterans Memorial set up, and we made a satanic one. We made a satanic one after they approved the design. We had submitted them. So we went through the massive effort of having this thing constructed, put together, and artists create the design for it and everything else within the specific parameters of what could go in this park. And then we get all the way to the point where we're looking to schedule shipping and installing it when suddenly the city council votes that they're going to shut it down entirely, at least long enough to not have the Satanists there. And we're really handicapping ourselves if we don't confront this and call it for the bullshit that it is. Sorry, Stu, go ahead.
And Belle Plaine, I would say, was the third time that this happened. So what we see in the pattern is that there's this basically they change the rules retroactively based on pretext. And this happens time and time again. So the first time that I saw this was in Phoenix. Before we sued Scottsdale in Arizona, we were looking towards Phoenix. That's when this whole public prayer kind of campaign started. And what happened is they changed the rule that only people from living within the city boundaries of Phoenix, Arizona, could do the prayer. But the only reason they did that was because they heard on the media that the Satanic Temple in Arizona was based in Tucson. It's the only reason they did that. And it would be legal to change that rule. But what happens is clearly the rule change is based on pretext. It was an over 60-year tradition. And then what they attempt to do is apply it retroactively, saying, and clearly we know why they did that. We actually ended up prevailing in that without lawsuit because they just, like you said, they just took down the public forum and they had their fun for 60-something years. Until there was any kind of idea that they didn't like, and they just tore down the whole entire system, similar to Belle Plaine. The other time we saw it was with the Baphomet case in Arkansas, where there was a public comment, like order of operations, when there was going to be a monument placed. So I guess to prevent the circus, their pretext, I don't even know if they had a pretext for that one other than that they didn't want the public comments. They changed the order of operations and tried to apply it retroactively to us so we wouldn't get the opportunity to have the public comments. So in our first three, I believe
somewhere in there they called an emergency too. I don't remember what it was, but they were passing some order of operations type of new rule through the procedures of the office, whatever. And I just remember that laughably they designated it an emergency, and clearly the emergency was us.
Yeah, well, they did that because it wouldn't have gone into effect immediately otherwise. If it was a statutory change, so if they didn't put in an emergency clause, then the law wouldn't have taken place until August, which was like 4 months later, and we had already passed the next stage, such that the following thing was public comment. So in order, I mean, this is a huge part of our case, is in order to preclude the public, it was because of that. There was no other, I mean, hell, Rapert, the guy who introduced and wrote the bill, went on Facebook Live and said it in so many words.
It's a cold day in hell.
Whole
right?
day in hell.
But this is what the government does. I mean, we see this in the current regime too. Whenever the government wants to overstep people's rights, they declare it an emergency. So with us, it's easy to do, right? The evildoers are coming, right? So they just make an emergency. It's pretextual, and they try to apply it retroactively, which is illegal. But this is how they have been getting around this. And the other point I wanted to make, which Matt was saying about Marsh v. Chambers, is one of the things that they're relying on to do this is this false notion of tradition, where all of a sudden tradition, oh, we've been doing this for so long, that it seems to the courts are allowing it to override things like due process and the retroactivity applying, these pretextual concepts, when they're like, well, we can't let these new weirdos come because it's against the tradition. And that's something that I find like legally offensive, so to speak.
Well, you both represented the Satanic Temple in our Scottsdale case, and the Scottsdale case was also one of those where we had set up to give a public prayer before a city council meeting, and they had no standards in place, really. They were just going by what they felt like, and they were putting people on the schedule who would say they wanted to deliver a prayer in advance. They originally said, yes, the Arizona Satanic Temple could go ahead and do a prayer. Then it was taken off the schedule, and they never bothered to change the rules. The argument just hinged on their claim that the city manager thought the rules went a certain way, and they prevailed over us in that case. That's, to me, that's absurd.
I agree it's absurd, but I just want to put a fine point on it. The reason why we prevailed was because the judge refused to find that the guy had lied under oath. That's an important distinction from, for example, Boston 1, in which we didn't even get to the opportunity to even ask the questions. We weren't even allowed to depose the decision makers. We were allowed to depose precisely one of them.
And I still stand by the fact that what they do is, if it gets to the point of trial, which is rare, they're going to feign ignorance, and that seems to work. In Scottsdale, it was absurd because there were so much of the heckler's veto, so to speak, that it shut down the servers of Scottsdale. Yet we have a witness on the stand saying he hadn't heard of that. Like, this is a guy that could have sent an email that day, and yet he hadn't heard of it. And that him feigning ignorance was actually what ruled, which was why we lost. Is essentially how I see it.
But I think our mindset has changed a bit. At least mine has. At the beginning, the thinking really was, if they shut down a forum like this because they don't want us in it, and then they have to shut it down for everybody, that's what they chose, that's fine. We can pack up our claim and go somewhere else, problem solved. But my mindset really changed around Baphomet when we're fighting to have our monument put up where the Ten Commandments already are, and the Ten Commandments still remain. And while they've been deliberating for years, we've heard nothing about this case. No ruling, nothing. The Christian nationalists who put up the Ten Commandments monument are loudly and publicly talking about bringing gospel into the public square, for one thing, completely giving the lie to their in-court arguments that this serves some kind of secular function. But they're also considering it a victory every day that the Ten Commandments monument stays up. So to us, it's unacceptable to just close the forum and say, okay, now everybody out. The game is over. The fun's up. It's like, no, we want an equal amount of time in the fucking forum now. We want an equal amount of time for Baphomet on the Capitol grounds that was given to the Ten Commandments monument. And really, I think we've had some really strong cases that have been thrown out on some really spurious grounds. And I think all it takes is for us to win one of them, or for us to get to that point where a few influencers or something notice, and there's public outrage over just the bad ruling on the grounds of principle before the corner is turned and things change entirely. But I think it's going to take some degree of public waking up. It's going to take people like I was talking about earlier, people recognizing our rights, standing for these principles, and realizing that this isn't a game, this isn't a prank, and that we need to exercise these rights and know exactly what they are. I think that is going to make a world of difference. So I definitely don't think this is a time, even though I'm talking about this list of losses, I don't think this is anywhere near the time to let up. I think even though we've been handed losses, we're often handed losses on really convoluted, I think, procedural grounds, technicalities. And the reason that is because I don't think they want to confront the questions of law. We just got the appeals court in Idaho, the Ninth Circuit. They upheld the dismissal of our case, our reproductive rights case over there, on standing grounds, not because our legal theory about our rights on standing grounds, not because our legal theory about our rights regarding reproduction. They haven't touched that. None of the courts want to touch that. Now they're insisting that we need to have a plaintiff. We can't be the plaintiff claiming that this is going to interfere with our religious rights. We need to pull some poor person from Idaho who's willing to put themselves in front of the well, I mean, to whatever degree we can keep somebody concealed, I guess we'd have to try to work out. But it's not easy being a plaintiff in a case. It's not easy getting into a lawsuit, and I think it's a horrific thing to ask of somebody, and I think it's a terrible disservice they do when they take a case like this and assume that nobody's really affected or that they won't be, even though we showed statistically that it's all but impossible that we won't that membership of ours won't be affected by this law, and yet they demand somebody put themselves on record anyways. But we'll do it. We'll keep fighting the fight. We'll keep doing it until they're forced to confront it. And I think that's what we have to do.
Something I want to make clear.
Go ahead.
Something I want to be clear about this too is that this fight was not easier 10 years ago than it was now. This was always an uphill battle, and we always knew that running up this hill we'd get taken out time and time again until we broke through. And that's the way that these kind of lawsuits go when it's a civil rights issue, a really fundamental issue that kind of shakes people at their core of what these rights mean. We always knew this was going to be an upheld battle, no matter who was in the administration. And this regime is not a monolith. This one dude doesn't control all the courts. Now, he would like to, but every time we file one of these lawsuits, and every time that there's an issue, there's different facts, there's different parties, there's different laws, frankly. And I do agree with you, Lucien, that when it turns the corner, I think it is going to be a cascade effect, because we're not the only ones that are concerned about these issues. There's plenty of people that aren't Satanists that are very concerned about what's going on, including Christians. And eventually it's going to be publicly recognized that this whole legal system of one religion supremacy is simply wrong. And the fight doesn't stop because we lose a case. We do the next case, and we keep bashing our head into that wall until it falls. And that's the way that all civil rights cases go. So there's always hope for this stuff, as long as there are people that keep fighting for it. So
when things start looking hopeless, and when it looks like we can't win, I think we just don't know when that gets to a point where we're primed to win, honestly, because it's not just us feeling this. And I think if you start getting judges, if you start getting more people recognizing the danger for what it is, and I do see people identified as Christian more and more speaking out against Christian nationalism, more and more speaking up for the principles that defend us, even if they need to add the caveat that they don't agree with us, even though they probably don't know what we believe to begin with, but they feel that it's something they have to say. I think at a certain point you get people looking at our cases with new eyes and realizing that the world they're building is one that has completely deviated from the one that they envision themselves defending in a prior iteration of their life when they got into public service. I think at a certain point, we're going to have judges looking and recognizing that the precedent they're setting is very consequential. And it doesn't matter if they view us with a certain amount of disdain or disregard or want to reject us as some kind of elaborate prank. They're going to have to realize the bigger picture repercussions. And I would have hoped that would have happened sooner. But I think sometimes when things are getting worse, or they appear to be getting worse, and sometimes when things appear to be getting more and more hopeless, that can be your best time to strike. And we're never going to be told when we've crossed a certain threshold. But I do think there's a corner to be turned, and I think we will live to see it happen.
I want to make a couple of points. First, I agree with both of you. But second, let's not forget our wins. We have not gone without victories in court. We've had civil cases in which have gone our way, non-civil rights, just garden variety commercial cases in which we are given the benefit of equal treatment of law. We've had out of Pennsylvania, very big ASSC case, After School Satan Club, went our way. Out of Memphis, same thing, TST versus Shelby County. They caved immediately. Don't forget our wins when we're talking about our losses here, because it's those wins that we have a lot of learnings to be had. What are the things that the courts are finding palatable? Those are the things that we really need to focus our efforts on. You know, that's not to say that we shouldn't also do the other things. This, for example, TSC versus Boston Tube matter, that I feel very strongly about this one in large part because it's the exact same facts. It's not like we came in and 60 years later and prayers have always looked this way. We are following the exact same path, using the exact same theories on the exact same facts, subject to Supreme Court orders that are binding. You know, it's not anything new here. So a decent amount of what we're doing is just kind of testing and seeing what are the things that the courts are going to agree with us on, and what things can they not disagree with us on. What things must.
It's worth pointing out too, I look at things pessimistically, and I feel like I'm always looking at the worst case scenario. So I don't mean to, disregard our victories. It's just we get a victory, and I'm looking ahead onto the the battlegrounds that are still active, and I can often get pretty pessimistic in that regard. But now that you mention it, it's worth pointing out also how many of our losses aren't actually losses. They're just the courts punting and refusing to hear the case. And that's how I feel about Idaho. They're saying, well, we'll hear the case when you put a plaintiff on record, just because they didn't want to rule on it now. They don't want to touch it. And I think they don't want to touch it because the law is on our side. And while it's frustrating that they're not, I think it's a good sign that they decide to reach so hard for the technicalities when it comes to throwing out our cases.
And that's not unique to us. I mean, it's pretty common that a court will not rule on the merits of a case if they could rule on what's commonly known as a technicality or some kind of procedural issue, right? Like the courts would rather rule on that than make case law that could affect things in adverse ways. So that's not just unique to us, in my opinion. But yeah, and another thing is I'm pretty proud of the fact that even though we lost the Scottsdale case, there was a ruling that we overcame the notion that Satanism isn't a real religion. We overcame that in that case, and I think that was very instructive going forward for us or even other minority religions, of the arguments that you could make to establish that religion isn't just what we consider like the Judeo-Christian or Abrahamic religions. There's a whole broad plethora of religions that can have legal standing, legal grounds to have these fights without how it was described 50 years ago, for example. So I feel like
it was an unexpected ruling because Scottsdale's attorneys argued that we weren't a real religion, therefore our religious liberty claim did not apply. And the judge was unambiguous after deliberating on the evidence and after everybody being cross-examined that We are in every way a religion and would be considered such in any other case. However, we hadn't proven beyond some kind of reasonable doubt that religious animus was at play when the city council decided to take us off the schedule from giving a prayer. So it was a bizarre kind of ruling that gave us a victory in one way, but overall, when it came to the core of what the case was about, it was a defeat.
I did want to point out something else with Boston. First of all, I agree. Yes, that was a very, I mean, this is called splitting the baby. Judges do that all the time. But going back to Boston, we talked about all these various other cases and how Boston's different. There's another key thing that none of us have talked about, which is that governments cannot, in the First Circuit, shut down forums because they disagree with the speech taking place within it. There's a very, very, very key aspect of our Boston case, because that's exactly what they did very clearly. And they're not even being subtle about it. They're coming out and saying, yeah, we are shutting down this forum because we don't want to be facilitating religious speech. So what we're doing to preclude that is excluding both the Christians, except for that one time, and anyone else who wants to follow in their footsteps. Well, there's a 1982 case that says you can't do that out of the First Circuit, which governs in this case. So that's one of those linchpin points. It's kind of the same thing as what I was saying earlier with Shurtleff, same facts, same law, same everything, same flagpole, you name it. Nothing's different here as of our May 3 application, which is what controls. Well, it's the same thing here too. You can't shut us out.
And do we not have a record of flags that have been flown since in Boston?
Yeah, that was another aspect of the case that we haven't talked about. We have introduced a few pictures of flags that have been flown since May of 2022. In the preparation stages for this lawsuit, I issued a public records request stating we want all applications. The new rules say ostensibly you need mayoral approval and you need to have a legal conveyance of the flag before it's being flown. It must be literally the property of the city of Boston. So I said, I want all those legal conveyances. I want all those mayoral proclamations. I want everything about all this. And they said, well, and importantly, I said, I want all applications dating back to May 1, 2022. Remember, our application was May 3, 2022. So we know that there's at least one application. We have the screenshot of it. It's part of the complaint. It's a web form. So we know there's at least one, and yet they said there are none. So another aspect, just setting aside the constitutional claims, is it's a public records violation for all the various documents that they withheld from us. That's another key aspect of the case. So we know that they've been flying flags. We know that they've been flying, as best I recall, there was like a Trinidad and Tobago flag. I think there may have been a couple other ones. I forget what. Caribbean American Heritage Month I see here as of June 7, 2024. There was another one I forget as well. And part of their motion to dismiss is, yeah, we knew what you were talking about, but we wanted to wordsmith your application to make it mean something that it didn't mean, which is not all what the law provides for. They're supposed to ask questions if they don't understand the application. They're supposed to, we contend, minimally use the dictionary definition of the words in interpreting the written application, which they did not do. The fact that
so when it came to the Boston City Council case where we wanted to give the prayer, we were told that we could not depose the mayor because she was just too important, even though the mayor was the one who, before she was a mayor, denied our request, wrote the letter, signed it, was apparently responsible for the entire policy, couldn't talk to her about anything. And then when we did depose some people, they were just more than happy to sit there with shit-eating grins on their faces and answer our questions with, well, you'd have to ask her, because they knew we weren't allowed to depose her. So our hands were kind of tied on that front. Do you think we're going to run into similar with this case? And who do you think we need to call as witnesses?
Well, it's a little early to think about a deposition plan, but a key aspect of why we were not allowed to depose Wu at the time, Mayor Wu at the time, is because she was not a defendant. So part of our course corrections here is we have named her as a defendant, and we have a very valid claim to do so because when you're seeking injunctive relief, the person who is going to be enjoined is a necessary defendant. You can't not sue the mayor if the mayor is the one who has to issue the proclamation. Literally, it would be grounds for dismissal for me to not sue her. So that defangs that aspect of things. In terms of
Doesn't one always call witnesses who aren't directly plaintiffs or defendants?
right, but and I agree with you that the proposition is wrong because at the end of the day, in Boston 1, she was a necessary witness if she wasn't necessarily a defendant per se, because she had, again, Boston 1 is a subjective intent question. It's not sufficient to say, well, I wasn't allowed in. You have to more particularly say, I wasn't allowed in because they were discriminating against me because of my religion. Say it differently, I was not allowed in. I would have been allowed in if I were a Christian. I would have been allowed in if I were a Hindu. I would have been allowed in if I were something else, not because of where I'm at or because of who I am or because of who my connections are, but because of my particular religious ideology. That's a subjective inquiry, which obviously you can only get to by asking the person, why did you not let this person in? So yeah, that was, I strongly contend that was legally wrong. The First Circuit affirmed, but I still disagree. That was wrong. We had to depose that person. But we don't have the same thing here. This isn't an Establishment Clause case. I mean, there's one Establishment Clause claim, but it doesn't matter what Wu does or does not say, or any of the other counselors or whomever does or does not say, because the ordinance itself expressly states moving forward, all flags will be the official viewpoint of the city of Boston. There's no ambiguity there. It's very clearly the next day, only the Christian flag is the only religious flag that ever got flown. So the key of this case, the core of it, remember, we're following the shirtlift footsteps. Those shirtlift footsteps didn't talk about the Establishment Clause. Those shirtlift footsteps talked about the free speech and free exercise hybrid claim. That's the real meat of the case. Everything else is just a couple of other arguments that we're tacking on that are obviously very correct, but not the core of it.
Yeah, well, in Boston, you get the impression that the judges know the mayor, they all know each other, and they're just going to throw out a case like this. And we had the situation with our last Boston lawsuit. Not only were we not allowed to depose Michelle Wu, but our opposing counsel, the Boston lawyers, they would just miss deadlines. And then they'd email and say, oh, sorry, we were on vacation. The judge would say, oh, yeah, whatever, go ahead. Well, at the same time, the judge put out an order where you needed to respond within like 24 hours with a whole briefing as to why you needed to depose Michelle Wu to begin with, kind of thing. So obviously, very different standards openly being held. With that in mind, do you care to make any predictions about how this one will play out?
I've had my appetite for predictions beaten out of me by the course of time. I will say at this stage, I don't see how the judge can give a straight-faced argument as to why we can be dismissed. Certainly as to the public records aspect of it. Certainly as to the First Amendment, specifically the free speech, free exercise aspect of it. Establishment Clause, I don't see how you can get around this notion that is a preference for Christianity. I mean, I guess the judge could just say, well, I just find that it's not, and then that'd be the end of it, kind of like they did with saying it's government speech. And so that's with Boston 1, they kicked out our free speech claim because they said it's government speech. You don't have a free speech claim. So, I mean, theoretically, the judge could do that. I don't see how she says that before this ordinance went into effect, it was government speech, though. So I'll say this, if we lose, it'll be a good appeal.
What are your thoughts on it, Stu? Do you have predictions of how this will play out?
Well, I agree with what Matt said. my predictions have been beaten out of me by years of doing this and watching this, and even practicing other aspects of law, typically criminal law. It's really hard to predict. Especially it depends on procedurally how it goes. Because I think when it comes down to it, our basic arguments are correct. It's just, how is the court going to treat some of these procedural aspects? How is the court going to treat things such as, the tradition? Oh, this has been around since the First Continental Congress. You can't shake this up. This is, rights are kind of secondary to the tradition. There's strange things that happen like that. Or, for example, if it were to go to trial, you'll have witnesses that feign ignorance and things like that they'll hang their hat on because that's easy. So it's very hard to predict how these cases go. I think over time, especially with Matt, he's done so many of these cases now. I think there's a level of experience, and we kind of see the patterns. But I think the Court of Appeals is going to hear this case one way or the other. I'm not familiar with that circuit or that Court of Appeals that you guys are operating in Boston, so I couldn't really say. But I do think this is going to get sorted out at a higher court level, one way or the other. And we're still waiting for rulings on cases that we started a decade ago. Matt and I were talking about Baphomet recently, how we still don't have a ruling on summary judgment motions from those cases. So even on the cases we feel like we should have some sort of basis to have a prediction, we don't even have the rulings on those, on some of it. So it's really hard to say.
Yeah, I mean, presumably the Baphomet case is still just this time bomb waiting to go off. They could, bring it to trial, but I think the motions were for summary judgment at this point. So we expect that, being that there's no question, I have no idea what the judge would even want to explore in a trial.
And just to explain what that means to everyone is when you're on summary judgment, basically both sides in this case, for example, are saying we have no dispute of facts. This doesn't need to go to trial. We all agree on what happened, but one side's arguing that was legal and one side's arguing it's not. And even then we can't get a ruling. So, these might have razor thin margins on what the decision is, but we're the unpopular cause, so it's always going to be against us if there's a tiebreaker, I feel.
Any final words, Matt?
I do want to address a question in the chat, which is, under the current administration, do rules really matter right now? And you touched on this a little bit, that rules matter more than rulers, but I do want to emphasize, yes, rules absolutely matter more than ever when you have a administration like this pushing the boundaries, to put it lightly. And this kind of goes to a repeated point that I keep using in my briefs, that the First Amendment didn't come from a vacuum. Our religious freedom concept didn't come from 1946, this very important case called Everett, which is what basically set out the Establishment Clause and the notion that the First Amendment and the Bill of Rights are the core. These are fundamental rights. You can't screw around with this. These notions came from the impetus of the founding of this country, and it came from painful experience. They were literally killing each other in the streets of England before and because of our religion clauses, which is to say, we looked back at that and we said, we don't want that to happen here, so we're going to make changes to fix that. If the rules don't matter, then we're going to continue step after step in that same direction of killing each other in the streets, because someone wants to use the government to push their religious ideas.
The rules and the laws, they matter now more than ever when you do have an administration pushing the boundaries. Like I was saying, and I feel like the point is worth making again, when there's pushing those boundaries, the reaction is important. And if the reaction is that when they put out a memo that says you can proselytize to your workers, and everybody says, oh, Christians can now proselytize to workers, and they internalize that, they know that then they can more easily codify that into law. And the reason I think they're not doing that now is because they don't know generally what the reaction is. They don't know to what degree they can maintain their base if they deviate too far. They don't know to what degree they can actually be hypocrites before people wake up, even in their own camp, and say, this is obviously not constitutional. This is obviously not the America I claim to be a patriot for. And they start having some kind of awakening. That all those things can happen. And when they push the boundaries, they're not willing to push them all the way to this breaking point where things collapse down around them. That's always going to be the concern. We always need to be vigilant on these things, and we always need to respond appropriately and show that we're paying attention and not give up, just on this idea that the rules don't matter anymore. Because we have seen this administration react when told that it violates the law, and actually try in their kindergarten kind of mentally untalented way to contort and massage these things to make them at least, give them some kind of flavor of constitutional legal approval. So I think the way this goes does partially depend on the public reaction and how we exercise our rights, identify our rights, and understand those rights. And that's about an hour. So thank you, gentlemen, for being with me. We'll have to do it again more soon than the space we took between this and the last one. But as always, lovely discussion.
Thanks for having us.
Thank you.
Thank you. Good night.